Hello, everyone, and welcome. Welcome to our first Fenwick Elliott webinar of 2021. And on that note, Happy New Year, if I haven't spoken to you already. It may seem like a distant memory now, but I hope you all had a wonderful holiday at some point, and possibly, no doubt, much more quiet this year, given the circumstances, depending on where you are in the world. We took a short break over December, the December holidays, and it's fantastic to be back with you today and have so many of you joining us again. For those of you who I haven't met, my name is Stacey Sinclair. I'm the head of technology and innovation here at Fenwick Elliott. And to kick off 2021, in today's webinar, we are going to discuss getting paid in the era of COVID-19. And our superb speakers today, we have with us Fenwick Elliott partner Andrew Davies. Andrew has 20 years experience specializing in all things construction, avoiding and resolving construction, engineering, and energy disputes throughout the construction supply chain. We also have Laura Bowler, a Fenwick Elliott associate, who also specializes in construction, engineering, and energy disputes. And she is regularly involved in litigation in the TCC and the Supreme Court. And we are particularly delighted to have Michael Smith, a barrister at Three Stone Chambers, with us today as well. Michael specializes in insolvency, intellectual property, and general commercial litigation. And perhaps his insolvency experience is particularly evidenced by the fact that Michael is a co-author, editor of a leading insolvency textbook, Shaw, Miller and Bailey, Personal Insolvency Law and Practice. So before I hand over to our speakers and our topic today, just a reminder to those who have not been with us before, please do ask questions as we go. You should see on the right-hand side of your screen, or possibly elsewhere, a toolbar with a questions box. I will do my best to capture as many of those questions and put them anonymously to our speakers at the end of the session. And do rest assured that the slides and an on-demand recording of this webinar will be available on our website within the next few days or so. So with that, thank you everyone for attending. And Andrew, I shall hand over to you.
Thank you, Stacey. Good afternoon, everybody. Today we're going to talk about getting paid in the era of COVID-19 and also hanging on to money in the current climate. Stacey and I talked about putting this webinar on before Christmas, but we decided it wasn't appropriate due to the distinct lack of any festive cheer in what we have to tell you. Let's cut to the chase. It's tough out there. We assume our audience relates to standard solvent companies, and getting paid and hanging on to money are, in the current climate, difficult. Laura and Michael are going to tell you about the steps that the government has taken that, whilst it's not their intention is to help struggling companies, the effect for standard solvent companies is that getting paid will become harder. There's anecdotal evidence which our senior partner Simon Tolson was reported as telling us in Construction Inquirer earlier this week. Belts are tightening and cash is not flowing as it should. Further, turnover and therefore jobs are being protected by low bidding. And we know from experience after the 2008 global financial crisis that this doesn't end well. Is there any good news? Well, we've got a new business secretary, Kwasi Kwarteng, who supports construction, and he's confirmed this week that work will carry on despite the pandemic, albeit slightly differently. And construction is in a better place than other industries such as, say, hospitality. And I also read this morning that the good and clever things that people are doing on site to get around COVID restrictions are solutions that could, in due course, give rise to R&D tax credits. So perhaps something to look forward to. So today, I'm going to give you some tips on what you could do before the contract is entered into to make the position better. And whilst you're in contract, some tips to help you get paid, maximize payment, and hang on to money. Laura will then tell you about something the government's done that may have the effect of tying one hand behind your back. And then Michael will tell you about further measures the government has introduced and what that might do to your other hand. So pre-contract, these are things that you can do in what I call a down the line situation, so flowing down the contractual chain from an employer to a main contractor or from a main contractor to a subcontractor. First and foremost, you should do due diligence on the other contracting party. Check their solvency, look at Companies House. There are also other resources such as Dun & Bradstreet reports, or other organisations such as Red Flag will tell you all you need to know about the other contracting party. The second thing you might want to think about is a performance bond. If a company has got bad credit, they're unlikely to be able to provide a bond. So providing a bond, or their ability not to do so, is often a good litmus test of financial strength. Parent company guarantee. If a parent company guarantee can be provided, that gives extra security in the event of insolvency of the other contracting party. Retention. Retentions in a construction contract are typically between 3 and 5%. However, this is not fixed and is negotiable. And my non-contentious colleagues tell me that they've seen figures of 10% or higher being asked for by employers. Termination. Termination has been affected by CIGA, which Michael is going to talk about. But in a down the line situation, my understanding, and Michael will correct me, is that it will remain possible for a purchaser of supply services to include a provision where they don't have to continue the supply in the event of supplier insolvency. Step-in rights. This would allow you to take on key packages if the contractor becomes insolvent, step in and help the project. Latent defect insurance. This can survive insolvency and allow you to recover some money in the event of defective work, even after the contractor or the subcontractor has gone. Another potential way forward, project bank accounts. These are ring-fenced accounts from which every tier in the contractual chain is paid at once from the same account, and that reduces the risk of lower tiers being not paid by the tiers above them and disrupting the project. Where there are off-site goods, avoid paying for goods until they're on-site and integrated. Paying for off-site materials from a supplier that goes insolvent creates further difficulties that could be avoided. Another tip is weighted stage payments. If you're in an employer situation, you may want to backload these payments so that there's less payable at the start of the project and more payable as it nears completion. So what can you do in an up the line situation? So this is steps a contractor should take vis-a-vis employers or subcontractors vis-a-vis main contractors. In many cases, what I'm going to tell you should do in this situation is the exact opposite of what I've just said the employer should do in the situation. Again, we're hearing that short-term decisions are being made on a commercial basis to win work, but you should think very carefully about the long-term consequences of low bidding in this current climate. Again, due diligence, look at the solvency of the opposite party, check the usual sources. Termination, Michael will talk about termination in this scenario as a result of the changes introduced by CIGA. Parent company guarantee, again, this will protect your position if the other party becomes insolvent. Retention, again, opposite to what I said a moment ago about the down the line position. In an up the line position, look to reduce or delete the retention provision so that you get paid as much of the contract sum at each interim stage as is possible. Again, flipping what we said earlier on in relation to weighted stage payments, if you're in a down the line situation, looking up the line, you should try to get these front loaded, get as much paid as possible at the start. The best way to do that is an advance payment. Securing an advance upfront payment would certainly improve your cash flow. However, the chances of getting one in the current climate, I would suggest, are relatively limited. Another form of protection is an escrow account, an account controlled by a third party where payments are made essentially on a box ticking basis. No merits decisions are made, and this ensures that money will flow down the chain. So those are some things that you can do before entering into the contract. During the contract, so if some of the above tips are followed, the payment prospects should be improved. Records. This is a Fenwick Elliott standard. I've not seen a Fenwick Elliott presentation where this advice isn't given, but it's given because it's important. In the COVID climate and compliance on site with the latest guidance, we're now on version 7 of the CLC site operating procedures, things will be different. Things on site like hoists, other access to site like turnstiles will affect the ability to get operatives to the workplace. Social distancing, additional cleaning time, all will affect productivity. So you should record the delays. Most jobs on site now will have been entered into and certainly bid before the pandemic hit. They would have been programmed on a pre-pandemic basis, and there will be delays caused by the pandemic. They should be recorded. And any programs that were pre-pandemic should now be updated to reflect the difficulties that we've just outlined in access, social distancing, and the effect they have on productivity. Applications for payment, there'd be nothing worse than a month with no payment due to your own admin error. So timely and valid applications for payment are critical. In terms of timing and content, timing will depend on the contract. Similarly, in relation to the content of an application notice, that will depend on the contract. And I've seen contracts and subcontracts with onerous provisions as to what must be provided in an interim application for payment. The Construction Act helps not with the content of an application for payment, but what an application for payment must contain in order to be considered as a default payment notice. And the baseline here, in my view, is pretty low. They must contain the sum that the payee considered to be due on the due date and the basis on which it was calculated, a relatively low bar to clear. What about adjudication, winding up, or other action against the company that owes you money? Well, Laura and Michael will explain the effect that CIGA has had on these tried and tested strategies to obtain payment. Suffice to say that they are not as easily available in the current climate as they were pre-pandemic. So how should you try to keep hold of money in the current climate? Again, notices are very important. They need to be given on time, and their content needs to comply with either the contract or the Act. In terms of timing, a payment notice must be given 5 days after the due date. This is enshrined in the Act, and the contract must follow the Act. A payless notice, by contrast, there's no set period in the Act, and it's all down to the contract. They can be given as late as 1 day before the final date for payment. Sorry, I've moved the slides on inadvertently. Forgive me. The content of a payless notice, again, depends on the contract. The threshold in the Act is also pretty low. It's the sum that the payer considers to be due on the date that the notice is served and the basis on which that sum is calculated. It's a pretty low threshold, and in my view, it's less onerous than the old withholding notices. You can't give a webinar or a presentation on the subject of insolvency without mentioning the Supreme Court decision in Bresco from last year. The headline from Bresco was that the Supreme Court found there was jurisdiction for insolvent companies to refer disputes to adjudication. The Supreme Court went further and actually said that adjudication in such circumstances was positively encouraged. So adjudication is a weapon that is very much back in the insolvency practitioner's arsenal. A number of conditions do, however, need to be met. The main one for the adjudication itself is that it cannot be about only part of the parties' differences. It must arrive at what they call the net balance due. So essentially, it's a full final account dispute. Further conditions are imposed at the enforcement stage. These are known as the medicide conditions after a case of that name. Things like ring fencing money, providing security for costs. If these conditions are met, it may be possible to enforce the adjudicator's decision. The reasons for this, you'll be aware that the ethos underlying adjudication is that you must pay now and argue later. If an insolvent party is successful in adjudication and squirrels the money away somewhere, the ability to argue later is taken away from the other party. So this is what they're trying to preserve. What Bresco did was it moved the decision from the adjudicator to the court at the enforcement stage, opened up the ability for insolvent parties to refer disputes to adjudication, notwithstanding that their difficulties remain at enforcement stage. And commercially, in my view, that will have a huge impact. It is possible for an insolvent party with whom you have a dispute to commence a distracting adjudication during the course of the pandemic, and causing distractions that, frankly, you could do without, because there's, as Laura's about to tell you, further things that you need to worry about. Thank you. Laura, on to you to look at the temporary things introduced by CIGA.
Thank you. So, as many of you will probably be aware, the Corporate Insolvency and Governance Act 2020, or CIGA as it's colloquially become known, came into force on 26th of June 2020 with the overarching objective of providing businesses with flexibility and breathing space in order to continue trading during the coronavirus pandemic. Briefly, the Act brought in a combination of temporary and permanent measures, which were aimed at helping companies during the economic uncertainty. As Andrew's already alluded to, Michael's going to talk about some of the more permanent measures CIGA brought in, and I plan to talk about one of the biggest temporary measures, which is the restriction on winding up petitions. So, Part 1 of Schedule 10 prohibits any petition for the winding up of a company based on a statutory demand being presented after the 27th of April 2020. Whilst the Act didn't come into force until June, it is important to note the retrospective nature of the Act and also note that this is a complete prohibition. As such, if any statutory demand was served on a debtor before the 1st of March 2020, then a creditor is unable to rely on the statutory demand to support a winding up petition. This restriction is important because a common tool for parties who are seeking to pay an uncontested debt is through the use of statutory demands. Unfortunately, because of this temporary moratorium on the use of statutory demands, a debtor can ignore the statutory demand at least until the moratorium expires. Originally, as it says on the slide, the restriction on the ability to commence winding up procedures ran up until the 31st of December 2020. But due to regulations that were brought in on the 29th of September last year, this was extended to the 30th of March 2021. At the moment, it hasn't been extended, but given the country is in lockdown restrictions, there could be another extension to this restriction, so it is worthwhile keeping an eye on this particular section of the Act. Does it mean a complete ban on winding up petitions? Not completely, but yes, if you're planning to rely on a statutory demand. If you're planning to wind up a company on any other grounds, you must have reasonable grounds to do so, and they're set out in Part 2 of Schedule 10 of CIGA. These reasonable grounds are that coronavirus has not had a financial effect on the company, or that the relevant ground for the petition would have applied even if coronavirus had not had a financial effect on the company. It is important to note that it's an either-or test. The reason that that's important is that for Lim 1, it's going to be very hard in the current climate to prove that coronavirus has not had any financial effect on a company. And that, to a certain extent, is supported by the case of Ria Company, which was heard last year. By way of background, in that case, a company had issued an application to restrain the advertisement of a winding up petition by the first petitioner and to restrain the presentation of further winding up petitions by the second and third petitioners. The company in that case was able to provide evidence that its ability to return to solvency through refinancing efforts had been impacted by the coronavirus pandemic. As such, it was held that there was insufficient evidence. In that case, Judge Barber confirmed that it was clearly intended to be a low threshold, noting that the requirement is simply that a financial effect must be shown. The court, as a result, granted an injunction restraining the advertisement. It would probably be easier to bring a winding up petition under the second limit Schedule 10 test. It is important, though, that you demonstrate that the company was in financial difficulty prior to the coronavirus pandemic, and that was done in the case of the unreported Reed Tundrell Limited. In that case, the petition was issued on the 1st of May 2020 by a creditor to whom the relevant debt had been assigned in March 2020. Whilst the petition was 8 weeks before the formal introduction of CIGA, the retrospective nature of the Act meant that at the time the petition was presented, the petitioner did not meet the requirements under the Act for the petition to be presented. However, in that case, the petitioner argued that although the underlying debt had been assigned to the petitioner in March, the debt itself dated back to April 2019 and as a result predated the coronavirus pandemic. By reference to filed accounts, the business had been insolvent since 2018, and although the company disputed this, it was ultimately unsuccessful. In giving his judgment, Judge Mullen acknowledged CIGA and the restrictions it imposed, noting that he could only order a winding up petition where coronavirus had had no financial effect on the company, or that the grounds for winding up would have existed in any event. He concluded in this case that the company should be wound up. This at least shows that in the right cases, winding up petitions could still be used. So, to conclude, although the temporary measures introduced by CIGA appear to be beneficial to the debtor rather than the creditor, because of the ability to use winding up petitions to recover money has been impacted, it is not a complete bar to winding up petitions, as you can bring a claim under the second limb, and more importantly, at the moment, it's planned to end on the 31st of March 2021. I'll hand over to Michael.
Good afternoon. Today I'll be talking about three different topics. The first is the new moratorium procedure that was inserted into the Insolvency Act by CIGA. The second are the new restrictions on termination provisions in supply contracts. And the third is the return of HMRC as a preferential creditor. One important thing to note about all these things I'll be talking about, something that both Laura and Andrew alluded to, is that they are permanent. They were in fact planned before CIGA, and the fact that they were rushed in alongside other CIGA COVID provisions does not mean they will disappear when this crisis is over. Starting with the new moratorium procedure, I will first give you a brief synopsis of what it is, then go into the background, the eligibility and procedure for obtaining a moratorium, the effect of a moratorium, and the duration of a moratorium. So starting with a brief synopsis, the moratorium is a procedure that is designed to give companies in trouble a little bit of breathing space while they formulate a strategy either as a rescue or to go into some other insolvency process. All of this is done under the supervision of an insolvency practitioner who has the title of the monitor. The background to these proceedings is that there were certain moratorium provisions that were tacked on to various insolvency processes, but there was no general moratorium. For example, when a company wanted to enter into a company voluntary arrangement, it could apply for a moratorium, and certain actions that led up to an administration or the administration itself trigger an automatic moratorium. As I said, there wasn't a general moratorium for companies who were in trouble, And in the absence of that, it was observed that there were a number of problems. The first is that companies under pressure, often with a winding up petition pending, were forced to make decisions without proper advice and without really thinking through what they were doing. And the second is that companies were taking preliminary steps towards CVAs and administrations when they weren't appropriate, or even worse, they were entering into CVAs and administrations when they weren't the appropriate procedure. All of that costs money, and in the end, it is always the creditors who pick up the tab of anything that costs money. So as a consequence, we now have a general moratorium. Moving on to the eligibility and procedure. The eligibility is any company except those that are listed in the Insolvency Act as being exempt. The key ones that you might be interested in are companies that are already subject to an insolvency procedure or have been in the last 12 months, private registered providers of social housing, and public-private partnership project companies. The remainder of the exemptions relate to various financial services companies which have their own moratorium and insolvency proceedings. The procedure for obtaining a moratorium, if there is no winding up petition pending, is simple. The company has to file certain documents at court. I'm not going to list them, but all they have to do is file those documents, and that's it. The company is in a moratorium. If the company has a pending winding up petition, it needs to apply to the court for a moratorium. It in effect applies alongside the same documents it would have had to file had it not had a winding up petition pending, and it will also need to put in some evidence to show the court that the moratorium is likely to achieve a better result for the creditors than if the company were wound up. If a moratorium is obtained, the effect of it, well, there are a number of effects. The three key ones I'm going to focus on today are: 1, there is an enforced payment holiday; 2, there is a restriction on insolvency proceedings; and 3, there is a restriction on enforcement and legal proceedings. An enforced payment holiday is given on all pre-moratorium debts and debts falling due in the moratorium, except for the monitor's expenses, goods or services supplied during the moratorium, rent in relation to a period during the moratorium, wages or salary at any time, redundancy payments at any time, and debts or liabilities arising under a contract or other instrument involving financial services. The restrictions on the enforced payment holiday means you can't enforce any of those debts, and the restrictions on payment of pre-moratorium debts mean that if the debt is covered by an enforced payment holiday, the only payments that can be made to a single creditor are the greater of £5,000 or 1% of the total unsecured liabilities at the start of the moratorium, unless the monitor or the court consents. So bear that in mind when chasing. It may be that the company can't pay you, and those are backed up by criminal offences, so the company won't be able to pay if it's over those amounts. The restriction on insolvency proceedings generally restricts anyone other than the directors or the Secretary of State starting insolvency proceedings. The directors can petition, and they can recommend a resolution for the winding up, and they can appoint an administrator. The Secretary of State can petition for a public interest winding up. Other than that, there are no insolvency proceedings that are allowed. So bear that in mind. If a company is in a moratorium, don't go presenting a petition, or it will end up with costing you a lot of money. If the directors do want to enter into an insolvency process, they need to inform the monitor. And finally, there are restrictions on the enforcement and legal proceedings. And the key one for everyone I anticipate on this audience is that no legal process may be instituted, carried out, or continued against the company or its property, except for certain limited exceptions and with the court's permission. I anticipate that this is likely to cover adjudications in the same way that the administration moratorium covered adjudications Obviously, that doesn't necessarily apply to adjudication coming the other way, as Andrew's already discussed with the Bresco. And there are also other restrictions in relation to landlords enforcing security or repossessing goods under an HP agreement, which I won't cover today. The duration of the new moratorium, the initial period is 20 business days. Watch out for bank holidays in that, because they're often missed. That duration can be extended for a further 20 business days just by the directors filing the right documents. It doesn't need the creditor's consent or the court's consent. With the creditor's consent or the court's permission, the moratorium can be extended indefinitely. And if a CVA is proposed during the moratorium will continue until the CVA is dealt with one way or the other. The moratorium can be terminated by its expiry, and when the company enters into an insolvency process, the moratorium ends, and whatever the provisions of that moratorium, of that insolvency process then apply. The monitor can terminate a moratorium in certain circumstances, and the court can terminate the moratorium in certain circumstances. That is all I want to say about the moratorium procedure, and I'm now going to move on to the new restrictions on termination clauses. I'm going to start by giving you a little bit of background, then look at the new provisions, and then a few ideas about how you might be able to protect yourself. As to the background, back in 1986, when the Insolvency Act was first passed, it contained a provision that stopped essential suppliers, which were then defined as the utilities, from threatening to cut off supplies unless all the arrears were paid. In October 2015, there were some big changes to this. First, the definition of essential suppliers was widened to include certain goods and services relating to IT. And the second big change was the introduction of restrictions on termination clauses in contracts for essential suppliers when the company was in CVA or administration. The new provisions inserted into the Insolvency Act by CIGA extensively widen the restrictions on termination clauses. They apply to all contracts of goods and services unless they are a listed exception. The listed exceptions are essential suppliers, because they are already covered, various kinds of financial services, aircraft equipment in relation to the Cape Town Convention, whatever that is, and contracts forming part of a public-private partnership. They are widened in another way in that they apply in just about any insolvency situation, not just CVA or administration. The effect of these new provisions is to disable a term of a contract to the extent that it provides that the supplier can terminate, that the contract terminates automatically when the company becomes insolvent. They also disable any term to the extent that they give the supplier an option to terminate merely because of the insolvency. And possibly most important, they prevent a supplier from exercising any right to terminate that arose because of an event before the insolvency period. So that's any breach of contract, including non-payment. And finally, they prevent a supplier from making the payment of arrears a condition of the continued supply. If the termination provision is disabled, the supplier is only entitled to supply if the office holder or the company, depending on the precise insolvency procedure, consents to the termination, or if the supplier persuades a court to give permission on the basis that the continuation of supply would cause hardship. This is likely to be a very high hurdle. However, there is no restriction on the supplier terminating because of an event that occurs after the insolvency. So if the supplier is not paid for supplies during the insolvency, any termination provision that allows that is still valid. And the same goes for any breach of insolvency of the contract that occurs during the insolvency after it started. So some suggestions on what you might be able to do to protect yourself. In addition to the very good tips that Andrew gave earlier on in the talk, you might want to take advantage of any termination clause or any leverage that the termination clause might give you before the company goes into any insolvency procedure. The second thing I would suggest is look at your contracts. Do they oblige you to provide goods and services? If you are not obliged to provide the goods and services, the fact that you can't terminate the contract is neither here nor there. There is no positive obligation to supply imposed if it doesn't exist already. And I would suggest look outside the contract to other rights you may have to terminate or suspend performance. One example I think you may be interested in is that there is a right to suspend performance for non-payment under Section 112 of the Housing Grants, Construction and Regeneration Act of 1996. That is not a contractual right, it's a statutory right, and the provisions do not apply to statutory rights. They only apply to contractual rights. So that's something worth bearing in mind. My final topic is the return of HMRC as a preferential creditor. First, I'm going to talk about what has changed. Then I'm going to talk about what is a preferential creditor and why it matters. Then I'm going to have a quick look at the background to the change. And I am then going to look at the likely effect and perhaps give some suggestions that may assist you if you find yourself dealing with an insolvent company. So what has changed? For insolvencies commencing after the 1st of December 2020, HMRC is a secondary preferential creditor for the following debts. You've got VAT, and then what is described as a relevant deduction. That is where the company is required to make a deduction for tax, on account of tax from a payment it makes to a third party. The two key ones for those are PAYE and national insurance, and also CIS deductions. What is a preferential creditor and why it matters? When a company is in an insolvency, the order of priority of payment, if there's not enough to pay everyone, is as follows. The first is fixed charges are entitled to be redeemed in respect of the assets that they are attached to. So fixed charges will be paid first. The mortgagee of a bit of land will be entitled to take all of his security if the land is sold. Then you have the expenses of the liquidation. And if one thing insolvency practitioners are good at, it's running up expenses in a liquidation. Then you have preferential creditors. Then you have floating charge creditors. That is generally creditors who have a debenture or similar. Then you have unsecured debts, statutory interest, and then way down at the bottom, you have shareholders who very rarely get anything. The background to the change is that traditionally HMRC was a preferential creditor in respect of a number of debts, the taxes that are part of a new change plus a few others. That status was removed in 2003 because it was thought that it was discouraging enterprise and the rescue culture that the government at the time wanted to foster. This current government doesn't take the same view, and the change in status was announced in Philip Hammond in the 2018 budget. It wasn't implemented until the Finance Act of this year, and it does not apply to insolvencies starting before the 1st of December 2020. The likely effect, well, generally it will reduce the size of the pot for unsecured creditors, and it will reduce the money available for creditors with floating charges. Unsecured creditors, in my view, are likely in most small to medium insolvencies now to get nothing at all, save for anything that might come out of the prescribed part if it's there. Generally, there's a wider economic effect. This is likely to increase the cost of finance because unsecured creditors and floating charge creditors now bumped down the line. Banks are likely to price that risk into their costs, and it will have an inevitable effect of increasing interest rates or possibly conditions that the banks might seek. So what can you do if you are a creditor and you're trying to improve your position? Well, the first thing you can do is to look outside the pot. Look for guarantees, personal or parent company guarantees. Andrew's already discussed. You can look for these at any time. They don't have to be pre-contract. Provided the company is not yet insolvent, you can try and persuade the company to give you a guarantee or similar in order to continue supplying. Obviously, for the reasons I've discussed, that option will die when the company goes into insolvency. Or you can seek to improve your ranking. The key way to do that is to seek security. You can do it by agreement, preferably with a fixed charge. If there's an asset you can point at and say, I want security over that. Or a floating charge. It's not as good. You'd be after HMRC on the new provisions, but you'd still be ahead of unsecured creditors. And if you've got a judgment, a court judgment, you can seek a charging order over the company's assets, and that will have effect as a fixed charge. So you will be entitled to take your money beforehand, before any of the creditors are paid in the liquidation. So with that said, I will now pass you back to Stacey, who I believe will be marshalling the questions.
Thank you very much, Andrew, Laura, Michael, for that hugely helpful and detailed review of CIGA and the options available in getting paid. I found it particularly interesting. I'm sure our audience did too. And thank you everyone out there for sending in such brilliant questions. We're going to try now to get to as many as we can. I can see that we're not going to be able to get to all of them, but thank you again for sending those in. Michael, if we could start with you. We've had a couple of specific ones for you. You'll be pleased to hear they do not relate to the Cape Town Convention. But the first one is, could you provide a typical example of how you could demonstrate that a company's ability to pay had not been impacted by COVID?
This is Laura's topic. I've done it very recently by looking at the company's last filed accounts, and the debt in question was a judgment debt that we obtained after a trial during COVID, but it related to debts that were way before COVID, and they hadn't recognized our debts in the accounts, and our debts were bigger than the net assets. So that is a very simple way to do it, to say our debt is bigger than the whole value of the company was before COVID. So that is your typical way to do it. It might not be as extreme as that, but if you can look at knocking out the kind of tangible assets or the current assets with your debt, and your debt arose before COVID, then I think the court would be keen to listen to you and say, well, we'll wind up, or at least throw a burden onto the company to say, no, now you've really got to show why the COVID is actually the effect of your insolvency, not it didn't exist beforehand.
Great, thank you. And the next one is, how quickly is the existence of a moratorium made public to ensure claimants do not go to the trouble and expense of launching a claim, which will be ineffective?
I will have to go to the Act. There is a provision for publicity, but I don't have it at the top of my head, so I will go to the Act, which is right in front of me.
If not, we can always get back to our audience member separately. So if it's to hand, fantastic. If not, we shall we can get back to you.
Obligations to notify. Sorry, I think perhaps my computer's now playing up, so I think perhaps I can come back to it in a moment.
Yeah, we can come back to that, or alternatively, thank you again for the question out there, and we can get back to you separately on that one. We had a very helpful question in advance of the webinar. Is delay in the progress of a contractor or subcontractor caused by a COVID-19 a ground for paying less? Anyone want to field that?
I'll take that. Well, it very much depends on the provisions of the contract. I would suggest that very few contracts entered into before the pandemic would have an exclusion. There should be a way to have COVID as a ground for an extension of time. In terms of the process, as I said in my talk, the bar for a pay less notice is pretty low. All that needs to be shown is the amount that's going to be paid and the basis on which it's been calculated. but the underlying bases for the calculation and the bases for paying less will depend on what's in the contract. It's not possible to give an answer on that, and looking at COVID as a ground for delay is probably another webinar in the program, Stacey.
And on that point, if I can direct the audience to the Fenwick Elliott website that has a number of on-demand webinars from the past on COVID topics. There's been a number of questions, and thank you again, in the questions box about contractual provisions around force majeure and COVID, and et cetera. We certainly will have more webinars on that in the future, but if I can direct you to the website as well for some of those. Yeah, yes, hi, Michael.
I have the answer now on the notification. As soon as is reasonably practicable, after the moratorium has come into force, the directors have to notify the monitor, and then again, as soon as reasonably practicable, after receiving that notice, the monitor has to do a series of notification steps. And the two key ones I think you might be interested into are the registrar of companies, so it'll go on Companies House, and to every creditor of the company to whose claim the monitor is aware. So you should expect notice pretty quickly.
Excellent, thank you. Thanks for looking that up. One or two further ones I think we have time for. What are the panel's thoughts on the risks? Andrew, I think you were talking about retention previously in the first half of the webinar. What are the panel's thoughts on the risks of increasing retention sums, as suggested, and the fact that this effectively reduces a contractor's cash flow and perhaps therefore increases the risk of default or insolvency?
That's an interesting point. The questioner has it absolutely right. The higher the retention, the less the net payment the contractor receives, the less their cash flow, the less that goes into their bank, the higher the risk. It was a tip for an employer so that the converse would apply. They would be paying a smaller percentage of the amount and keeping the money in their bank. If I were advising a contractor, which I normally do, I would say get the retention as low as possible, increase cash flow, and decrease the prospects of an insolvency event.
Great. Thanks, Andrew. I think we do have time for another one. I think we should actually end on this, because Fenwick Elliott webinars do like to talk about records. We can't help ourselves, can we? But obviously, ever so important. Can Andrew or Laura or Michael, can anyone say something a bit further about these records and what contractors should be reporting?
So for example, in a daily site diary, if there's a particularly congested area of a site, for example, a plant room, where social distancing is important to maintain, but the effect on that is that where there would usually be pre-pandemic 10 operatives in there can only be 2, 3, 4 operatives. Record the number of operatives who were in there, what they did on that day, and possibly what they weren't able to do that the other operatives would have to do at another time. You're reducing the productivity by 50%. That's going to have an effect on the work. So record in the side diary what was done by whom and what was not able to be done by the operatives on that day.
Great, thank you, Andrew.
Can I just add a little bit of that? So this is more from the point of view of acting for and against liquidators in claims. I couldn't come anywhere near anyone who's either on the panel or in the audience about the ins and outs of construction. But one thing that I know liquidators don't like, from the point of view of they think they'll lose, is a clear, comprehensive documentary record. They love a big gap where they can kind of not make it up, but bearing in mind the liquidator wasn't involved when the project was going on. If there's a gap, they'll just say, well, it was obviously that the gap is evidence of breach or whatever they're trying to prove. The gap will be evidence of that. And particularly contractors who come off site at the end of, when the insolvency happens, and they may find that the liquidator is saying things about the site that they don't agree with, but they no longer have access to the site to say, no, we completed this work, and here's what we submitted to the quantity surveyor, and this is why we should be paid, or whatever it is, or if the liquidator is coming back with a negligence claim or something. So having as much documentary evidence is good. Is good for dealing with claims by or against the liquidator in the insolvency procedure.
Thank you, Michael.
And just for the third record in records. Worst case, put it in an email and send it, because if it's not in a formal site diary or however the site conducts daily business, you need a record and it needs to be somewhere. So even if it's in an email, send it.
Super. Thank you, Laura. Thank you, Andrew, Michael. That's been brilliant and a fantastic overview. Thank you very much, audience, for all of your questions that have been submitted. People are asking for the slides and a recording. Again, those will be available on the Fenwick Elliott website. And I would just like to, in the usual way, mark it, our next webinar in 2 weeks' time. And we have our partner Jatinder Garsha and Edward Colclough, who will be speaking about contractual liabilities post-completion. That is in 2 weeks' time on the 28th of January, again, a Thursday at our usual 12 o'clock time slot. And we would love to have you join us again. But thank you, audience, for joining us today. Andrew, Laura, Michael, thank you again. It's been brilliant. And nothing left to say, but I hope everyone out there is keeping safe and well, given the circumstances. And we hope very much to see you virtually again in due course. So thank you very much, everyone, and hope you have a great rest of the week and a good weekend.